Hi, welcome to Tort Talk. This is Terrence Gross, and I'm proud to be here with my law partner, Charlie Schuster, and my son, Rhett Gross. We are a personal injury law firm. I'm also glad to say that we are up to 5 offices in the Panhandle. Our primary office is in Pensacola, Florida, and we also have offices in Crestview and Fort Walton as well. We have opened up recently in Milton and also in Destin. And we see everybody for personal injury cases for a free consultation. If you're injured, you're in the hospital or at home, we could see you as well. My son, Rhett Gross, to my left, also practices criminal defense. And so we try to offer as many services as possible. We do car accident litigation, slip falls, a lot of dog bites, and other types of injury cases. We have a new website that we've just improved, which is grossandschuster.com. And again, you can reach us at our offices. You'll see the numbers on the screen probably throughout the program. And if you wish to call us for a question, we will take those calls. Do we have a caller? I think we do, and looks like line 1. Let's go to the lines. Welcome to Tort Talk.
Hi, I've heard you lecture before on insurance coverage. I still can't understand why I personally need any uninsured motorist coverage since I'm fully retired and have great medical benefits. I heard you give an answer a couple of years ago, but I can't remember why you felt it would be important for someone like me.
I love that question, and you wouldn't believe how many times I get that question over time, because I do lecture, I teach, and we've had seminars and so forth. And really, it all depends on what you're willing to forfeit or sacrifice, because Florida is what we call a 10-20 state. That means the average driver out there only has a $10,000 bodily injury limit per person, or $20,000 per accident. Not very much coverage. In fact, we're one of the last 2 states that has that type of low coverage. There's also exception under Florida law where you're not even required to have that. You don't even have to have bodily injury coverage under Florida law. So if someone hits you in the rear and you've got medical bills, some people have lost wages, maybe you don't because you're retired, but those are damages that you might want to recover. And then an important damage to me, some people skip over it. Some young lawyers call it pain and suffering damages, but it's really more than just pain and suffering, folks. It's pain and suffering, mental anguish, and loss of capacity to enjoy your life as you used to do. And those are big damages. So even if you're retired, and many people are active, you retire to do what? You retire to fish, you retire to golf, you retire to travel, to play with your grandchildren. If you've been robbed of those moments of your life due to the negligence of another, I don't know about you, but I want compensation. And no, it won't bring my health back. It won't alleviate my pain, but it allow me options. So if I were to get a settlement, maybe I'd buy a hot tub. Maybe I'd take a cruise with my grandchildren. Maybe I'd start a 529 plan for my grandchildren. It would give me those opportunities, because I'm not going to gamble that the person that hits me has enough coverage. And I'll tell you another thing I've learned over the years, I'm sure Mr. Schuster would agree with me, is that the worst drivers out there had the least insurance. The people that are responsible, that have full coverage, that do all those things are probably not the people that are texting while driving. They're probably not drunken drivers. They probably have better coverage and so forth, and they cause less accidents. So the people that are out there causing mayhem a lot of times have little or no insurance, and that's why you really need to have not only your basic no fault that'll pay 80% of your medical bills, but also your uninsured motorist coverage as well that will pay medical bills that have not been paid. For those people that may have lost wages, it will help them there. And again, the general damages of pain and suffering that I just spoke about. Looks like we already got a caller, Charlie, so I'm just going to keep the lines going, and let's see who is here. Welcome to Tort Talk.
Yes, I have a question for you.
All right.
My wife was slowing down to make a right-hand turn into her beauty salon when she was rear-ended by a deputy sheriff. The deputy called the highway patrol officer to investigate the accident, and they wrote up a report, but I don't believe the deputy got a ticket. the deputy was working on his computer and didn't see my wife slowing down. If he didn't get a ticket, do we have a claim?
Well, although I had almost that same case, I'm going to let Mr. Schuster speak up because he also is a personal injury lawyer and he can answer that easily.
Well, thank you, Terry. And that's an interesting question because I think everybody is aware of the concept of sovereign immunity. That is, you can't sue the government unless you have their permission. Fortunately, in Florida, we do have the government's permission in most situations to sue them if they're negligent and they cause injuries. In your particular situation, since the accident has now happened in this year, there is a limit of $200,000 that you can get from the government for an accident that they caused. Technical detail here is you don't actually sue the deputy, you end up suing the sheriff's department. You can't sue an individual. And another interesting detail is if you have uninsured motorist coverage, which Terry was talking about a minute ago, the government's considered to be uninsured. You can make a claim against your own insurance company instead of going against the sheriff's office. So yes, you absolutely have a claim here. People often ask me, and they say well, somebody did or didn't get a ticket. Does that make any difference in an accident? And the answer is no. In fact, whether you get a ticket or not is not admissible in court because other than the rare exception where the officer saw the accident happen, it's just his opinion on who's to blame and who's at fault. So for that reason, the fact that somebody didn't get a ticket is irrelevant to determining whether or not you've got a valid claim against them. So I think your wife has a good claim here.
All right, and one other thing about sovereign immunity, for those out there, the statute also says that lawyers can only charge 25%. So a lot of times on injury cases, lawyers charge 1/3 if you don't sue, 40% if you do sue. Under sovereign immunity, it's 25% come hell or high water. Looks like we have a caller on line 2. Welcome to Tort Talk.
Yeah, I was hoping that you might be able to answer a question for me. The other day I was in my front yard with some friends and family, and an officer pulled up. My nephew was out in the street with some other people, and they weren't really doing anything, but the officer was giving them a hard time. And so, anyway, they ended up searching my nephew, and they found some marijuana on him. It didn't seem right that they could just come in my yard and do that. Can they do that?
Well, I'm not going to answer that. I haven't practiced criminal law in 30 years, but the man to my left recently left the public defenders where he was at misdemeanors and in felonies, and I think, Rhett, you can answer that, can't you?
Absolutely. And that's an interesting question. I've had that fact scenario come in quite a few times over the years, and the fact scenario you paint kind of raises two issues, and I should state that they're both very fact specific, and it would come down to exactly what went on. But the two big issues that need to be spoken about are whether there was a legal search and whether there was a legal detention. So the big question is whether the officer had a right to stop your nephew, I believe you said, in the first place, and then whether he had the right to search him. The law on that is, in order to detain someone, the officer has to at least have reasonable suspicion of criminal activity. So you'd have to have some sort of objective facts that would that would allow him to be able to make that search. It'd have to be more than just a mere hunch or something like that. So if he had grounds to stop him in the first place, that may have been fine. Looking into it a little bit deeper, he may not have had that, and if that was an illegal detention, then an attorney might be able to help get that evidence suppressed. So it could have been an illegal stop, but it could have also been an illegal search. So on top of that, in order for him to conduct a search, he, one, either has to have permission from your nephew in that situation, or two, have probable cause to conduct that search. If he had neither, there's a good chance that the search was illegal, and ultimately be able to get an attorney may be able to ultimately get that evidence suppressed. If the evidence is suppressed in a case like that, the state would really not have a case. It's definitely a case where your nephew's going to want to talk to a criminal defense attorney to talk about his options before going to court on his own or anything like that. A conviction for that could have lasting effects. Even in today's day and age, there's possible suspensions of driver's licenses and possible jail time even. So I would suggest him contact an attorney to discuss that situation a little more in detail.
All right, good. Looks like we got another caller. The lines are lit up, folks, and let's go to this caller, and welcome to Tort Talk.
Hey, Mr. Gross. I got a question for you.
All right.
I know you're probably getting tired of car accident questions, but my son was in an accident a couple months ago. The guy that hit him only has a $10,000 limit, but my son's medical bills exceed that amount. Is there any way that we can try to get more money out of him?
Do you have any idea from reviewing the accident report whether the person that caused the wreck was driving his own vehicle or someone else's?
I believe it was his car, but I'm really not sure.
All right, good question. I'll try to answer it. And this is a good example of what I was talking about before on the first caller, is there's so many policies out there that are only 10,000. I would say 50% of the drivers, from what I can see, only have a 10-20 limit, the basic coverage in Florida. And this scenario happens all the time. So the first thing any competent lawyer is going to do, there's going to be a checklist. So you certainly get the coverage for the driver that caused the wreck. But Florida is what we call a dangerous instrumentality doctrine state. What that means, the owner of a vehicle is liable for the damage it causes. So we're going to try to find out and check and match everything up and see, was that vehicle owned by somebody else? If so, there could be a big policy limit out there that we don't even know about. A third issue that has been coming up a lot lately that I think a lot of lawyers may miss, but we don't, and it's this. We get an affidavit from the insurance company as to whether or not that driver was in the scope of their employment for somebody else. If I send my receptionist out for an errand and she's got minimal coverage, but she causes a car wreck, the officer is not going to ask her where she works or was she in the scope of employment. He's just going to ask her about her and her car insurance, so the accident report won't tell you this. But if that person was in the scope running an errand for my law firm or an accountant or any other big business, that business is automatically liable according to the doctrine of respondent superior, so that the employer is liable for the acts of the employee. So you could have, again, a hidden big policy out there that some people may miss. And then the fourth way, of course, what I talked about earlier, we're back to what? We're back to my favorite subject, underinsured motorist coverage. In fact, you made the comment, you said, Mr. Gross, you're probably tired of answering car accident questions. I'm not. It's what I do. 95% of everything I do is car accident cases. I teach at Pensacola State Junior College on the subject. I write for the Florida Bar. We give seminars. Mr. Schuster and I have a seminar on this topic coming up. So we live and breathe it. So we don't mind answering it. But when it gets to underinsured motorist coverage, it's really two things in Florida. There's some states where you have to buy uninsured motorist and a separate premium for underinsured. I've seen that. In Florida, it's one size fits all. So if you buy it's either uninsured because the person just didn't have insurance, or underinsured because you're arguing that your damages exceed their coverage. So you need to look at your policies. Under Florida law, we're allowed to stack coverages. You could actually add all the coverages of resident relatives within your household. So if you've got grandma living with you, if you've got Uncle Joe living with you, if your daughter moved out and she's back in her 30s because she's down and out, we get to look at her policy. So any policies of the household where you have resident relatives, we look at, and if you've got stacking coverage, you got 5 vehicles, we could stack all those coverages together, especially if your injuries are significant enough. So I think, yes, I think it's worthy of a consultation. These are the questions we ask at the first consultation to try to figure these things out to maximize your recovery, because you need coverage to prevail. Looks like we got another caller, so why don't we give it a try? We got plenty of time left. And let's go to the lines. Let's go to this one. Welcome to Tort Talk.
Yeah, Mr. Schuster, my wife was at a Save-A-Lot grocery store when she walked around the end of the aisle and tripped over a bread pan that was just lying on the floor. She was carrying a 5-pound can of coffee when she fell, basically flat on her face. She was taken to the ER with some abdominal pain. They didn't do any testing whatsoever and released her. We later found out she had ruptured something inside, leading to internal bleeding. This led to lengthy surgery and 30 days in the hospital. One of the doctors happened to mention that had they addressed this immediately, the surgery would not have been necessary. Is this a trip? Is this trip a fall case or a medical malpractice case? I just really don't know where I need to start.
Well, I'm really sorry to hear that about your wife. That's a very unusual situation, and the answer is yes and yes. You have both a premises liability case against the grocery store, and you have a medical negligence case against the emergency room for not properly diagnosing your wife's abdominal problems. When it comes to premises liability, a commercial establishment has a responsibility to keep their premises in a reasonably safe condition. And the fact that a bread delivery man comes in to stock bread and leaves his trays on the floor does not relieve the grocery store for responsibility. The delivery man's company is also responsible in addition to the grocery store. So yes, your wife has a claim against them for her injury. Now, here's the interesting thing about what you've told me. She also has a medical negligence case, and she can file suit against the doctors that misdiagnosed her condition and the surgery she had to go through and her hospitalization, or she can also make a claim against the grocery store for the doctor's negligence. And we have a doctrine in Florida that if someone is negligent and causes an injury, and you go and get medical treatment and the doctors make you worse, the person that caused the accident in the first place is responsible for all of your damage and all of your injury. The theory for that is, but for your wife falling in the grocery store, should have never gone to the doctor in the first place. So your wife has two potential claims. I can tell you that a premises liability case is oftentimes easier to resolve than a medical negligence case, which has a tendency to be a battle of experts. And this concept, this doctrine works in any kind of field where negligence is involved. If your wife was involved in an automobile accident and the doctors committed malpractice, the person that caused the automobile accident could be held responsible for the whole thing. So this is something that it sounds like you and your wife definitely need to pursue and you need to talk to an attorney about.
Well said, because it's actually a jury instruction. It's called a Stewart instruction. So Charlie's exactly right. And if that case came across my table, I would just go against the grocery store. And if they want to go against the doctors, they can. But it's just to get a medical malpractice case to court can cost in excess of $50,000 for a small case and much more, because the experts he's talking about, and multiple experts, and maybe they're getting them out of Vermont and Washington State, and you're flying around the country. So I'd rather stick to the grocery store, and the but-for test is exactly right, Charlie. Good question, good answer. Let's go to the lines and see what we have here. Welcome to Tort Talk.
Yes, hi. My son was recently arrested for a DUI, and he did all the tests and everything, but he barely blew over the legal limit, and he's talking about not getting an attorney, which concerns me, and just taking a plea, but I think he should get a lawyer. I think I know your answer, but should he?
Yeah, I know my answer. I used to do a lot of this work, but once again, this is something I haven't done in over 30 years. But Rhett, what do you think?
Absolutely. The short answer is he absolutely needs to hire an attorney. DUI cases are complex. There's a lot of defenses to those cases, even in the scenario, as you mentioned, where your son barely blew over the legal limit. What people refer to as the legal limit is the .08, and if people remember, before it was .08, it used to be .1, so they've dropped it down. That line basically creates a presumption. It doesn't necessarily mean the person is automatically guilty. So at .08, there would be a presumption that the person is impaired, but doesn't necessarily mean that there aren't any defenses. Each person handles alcohol differently. Some people are able to handle it a little bit more. Also, as time goes on, as you consume and your body absorbs that alcohol, it could change the amount that a breath test would read, which is ultimately guessing at what your blood alcohol level is. In addition to that, there's defenses such as going after the breath test machine. Sometimes the breath tests aren't reliable due to a problem going on with the breath test machine. And back to what I was alluding to earlier when we were talking about illegal stops. Maybe the stop and the initial stop was illegal, and therefore you would possibly have a defense. It's something that he definitely needs to go get a consult on. He needs to talk to an attorney. The consequences are lasting on a DUI, and you definitely need to seek a consult.
It's interesting because I started my career, and Charlie will remember this because he was a lawyer before me. I've been a lawyer now for 35 years. You've been at, 37 years?
37 years, yes.
And so I was a DUI defense lawyer back in from about 79 to 85, did a lot, as much as anybody. And over time, I've switched, and so no, I no longer do criminal defense. I'm glad Rhett's here to do that for us. He has that training. But what Charlie and I do now, and Rhett will be doing as well as his personal injury practice grows, is we actually prosecute DUIs too. So it's a weird situation because if you get rear-ended by a drunken driver, no, we're not criminal prosecutors, but we work very, very closely with Bill Eden's office, and his assistants share stuff with us. We write them letters. They'll share the videotape of the DUI arrest, the breath test results, alcohol influence reports, everything, videos, anything that we can get our hands on, and likewise we reciprocate. We usually help out the young prosecutors with their restitution hearings because we're tracking medical bills and lost wages. It's very time consuming, and as civil lawyers we keep up with it day by day. So we work with them, and it works out great. We may come up with some witnesses that they don't know about as we investigate the case. So truthfully, I'm a civil DUI prosecutor, and the key in Florida is if it's one of the exceptions to the general rule. Usually you cannot claim punitive damages on personal injury cases. If it's a drunken driving case, every single judge is going to allow you to amend your complaint to make a claim for punitive damages, not against the insurance company, but actually against the perpetrator who caused this by drinking and driving and causing an accident with injuries. So we take those cases, and invariably, you may not be able to get blood out of a turnip. We realize that, but usually the insurance companies don't like it when they're having to defend drunken drivers, and they usually pay us more for our compensatory damages. Once you join the punitive with it, it's something they don't want to go to the courtroom because there may be some people out there that maybe don't have a lot of sympathy for personal injury people, but very few people have sympathy for drunken drivers. So certainly our firm is a personal injury firm first, but yet Rhett does represent people for criminal defense, whether it be petty theft or the marijuana thing that the lady just called in or the man called in earlier, or even DUI. So anyway, we do have all these offices. In Pensacola, I'd like you to call us at 434-3333. In Crestview, it's 682-3000. In Fort Walton and Destin, it's 244-7191. And we're available at any of the 5 offices for any kind of consultations. Mr. Schuster and I, myself, for personal injury, and of course Rhett for personal injury cases as well as criminal defense. Charlie, any more party thoughts before we wrap up the program today?
Well, no, I think those were some very interesting questions that we did yet. We do have a fairly wide-ranging personal injury practice. As you know, you concentrate primarily on automobile accidents, but we also do premises liability, we do product liability, we do medical negligence, nursing home negligence. So basically, if you've been injured and it's the result of the fault of somebody else, we can probably help you.
And I'll tell you one area that, interestingly, we really don't do. I'm very candid with you that we don't do, and it's maritime. we do get those cases. There's boating accidents out there, and we are associated. We actually have on our letterhead of-counsel a very, very good lawyer out of New Orleans who also has offices in Mississippi and represents people throughout the whole Gulf Coast for maritime injuries, any type of boating accident. You could be out on just at the pass, and we had a case at the pass where it got too bumpy and a lady was thrown down and broke her leg, and yet that's a maritime type situation. So we're available for those, and if we can't help you, if there is a case that you call in that we personally cannot help you, we know the lawyers that can. That will, so we look at a lot of cases and try to help people. We take a lot of out-of-state cases. We take a lot of Alabama cases and Georgia cases. Rhett is licensed in Alabama, and we're all three of us are licensed to practice in the federal court here in the Northern District in Pensacola, the home seat for the Northern District. So again, those phone numbers for you to call us at are 434-3333 in Pensacola, 244-7191 in Fort Walton and Destin, and 682-3000 in Crestview. Give us a call if we can help you. Visit us on the web at grossandschuster.com.